Hi, I'm Tim Nies. I'm a Defense Base Act lawyer with Van Riper Nies Attorneys. I'm also a Ranger veteran, having served in the U.S. Army's 3rd Ranger Battalion, and I'm also a former insurance company defense lawyer. Today, I want to discuss with you, and this is especially for those that are still overseas but have sustained an injury and are waiting to come home, about 5 critical steps to follow after you sustain an injury overseas, again, with particular focus on what you should do before you leave the country to come back home for medical care. A lot of times, getting these early steps done correctly can make or break a Defense Base Act claim. So, step number one, and it's an obvious one, get medical care immediately and make sure it's documented. This could be at a CHS clinic, a Swedish hospital, another base clinic with a PA or a nurse practitioner or a medic you have, depending where you're at and what medical care is available. Don't try to tough it out. I've seen far too many cases where contractors delay care, and the insurance company, the DBA insurance company, later claims that the injury wasn't serious, was not work related. Equally as important, make sure that the medical care is documented and you leave with the paperwork. This includes clinic records, hospital records, maybe you had an x-ray, or even, depending where you're at, an MRI. So obtain those MRI reports. Also, if you can get the MRIs put on a disc to bring home to show it to your doctor here in the United States, that would be helpful. If you have photographs of any swelling or bruising or of any visible injuries, that would also be helpful. Any documentation created overseas and close to the time of the injury would be beneficial to your claim. Step number 2, and this is important, report the injury in writing to your employer. You have 30 days to report an injury. I don't ever advocate waiting to the very end. You should really do it as soon as possible, but do this in writing. An email will suffice, and keep it simple. Date of the injury, where it happened, what you're doing at the time of the injury. If there are any people or witnesses, you can put that in there as well. And most important, the symptoms that you're experiencing. So, say if you fell coming out of an MRAP and you have pain to your lower back that extends down to your legs, you're going to put that in the email as well, that have back pain with pain or numbness or tingling, whatever it is, going down to your legs. But say also you broke your fall by putting out your arm, and you have wrist pain, but to a much lesser degree. So you should put in that notification that you have back pain that goes down into your legs, and also to whatever wrist it is, your right or left wrist. A lot of times the insurance companies point to the fact that this injury, say the wrist injury, wasn't disclosed early on. So wherever you're having any pain or discomfort, document that. There's also a form online. It's LS-201 form called the Notice of Employee's Injury or Death. You can find this if you just search up Defense Base Act LS-201, and it will pop up, or you can contact my office and we can send it to you. Again, remember, don't give the insurance company a reason to deny your claim by not reporting it within 30 days, and preferably much sooner. And make sure you keep that email and notice. A lot of times, if you're doing this with company email, you lose access to that when you come home, meaning lose access to the company email. So make sure you print out that notification of the injury. Again, insurance companies, one of the first things they look at and ask you about is, did you notify the employer within 30 days? Because there is that deadline. Tip number 3 is don't leave the country without the medical paperwork. Ask for complete copies of the medical notes. Ask the treating doctor to state what he believes is your diagnosis, and that the records connect the injury to your job duties or the incident that caused this pain. Ask them to put in, and if there's any work restrictions, whether you can safely continue working, and also to document the fact that they're saying you should go home for medical care if that's what they're saying. Once you leave the country, getting the medical records from overseas providers can be slow or impossible. So obtain these medical records and bring them home with you. Also, on a side note, DBA pay is based on typically the 52 weeks of wages you earned prior to the date of injury. And a lot of times I've had people come home and then they lose access to ADP and they can't print up their wage records. So having those records early on is important. Tip number 4 is, be careful what you say to the DBA insurance company. A lot of times, I'm talking, I've seen a day after or a week after an injury, you may be contacted by a Defense Base Act insurance company or a claims adjuster or an investigator for them, and they want you to give a recorded statement. Remember this, speaking as a former insurance defense lawyer, nothing is casual, everything is documented. I highly suggest you talk to a DBA lawyer before doing this. But if that's impossible, when you talk to the adjuster or if you give a recorded statement, be truthful. Don't speculate. Don't minimize or exaggerate your symptoms or guess about medical issues. Stick to the facts. They may ask you about prior injuries in your life, so be prepared for that. Don't hide prior injuries or surgeries. I know a great percentage of the people watching this video are former military like me and likely have injuries. I myself was injured on a parachute jump, and don't try to hide the fact of the prior injury. Just tell them, matter of fact, yes, 5 years ago or 6 years ago, I had a surgery to repair my meniscus in my knee or ACL or a shoulder surgery, whatever it is. And just be honest with them, say it healed up. You probably disclosed it in a medical evaluation before you're even hired by this company. So, be truthful about that. A lot of times, insurance companies will bring up the fact that you didn't mention this injury when you're talking to your own doctors or an IME doctor or in these recorded statements. So be honest about it. But again, it's most important to talk to a DBA lawyer beforehand if you can, which is the last tip. Speak with a DBA lawyer early before problems start. Talk to a DBA lawyer while you're still over there. I talk to many clients on WhatsApp or FaceTime or on a regular phone. 20 or 30-minute conversation with a DBA lawyer while you're still overseas can help your claim. It's important. There's more information that a DBA lawyer can provide than these 5 tips. But getting a DBA lawyer after a claim is denied or your DBA compensation benefits are terminated or reduced, or after you're waiting for this one procedure, a particular type of injection, say a radio frequency ablation, then the insurance company is not authorizing it, and then getting a lawyer on board, and for that lawyer to get up to speed, obtaining all of the medical records, these overseas medical records, the wage records, all these documentation and other records that a DBA lawyer needs just delays the situation. But having a DBA lawyer early and having this file of these records is important. I know how these DBA claims are handled, and I go to bat for injured contractors, and there's a lot more information I could provide to you. So if you sustained an injury overseas and need to talk to a DBA lawyer, my website is defensebaseactlawyers.com. Our phone number is 772-283-8712. You can also contact us through our website. There's a form you can send, and I'll email it, and it'll email to me, and then I can respond back to you. Anyway, thanks for watching, and take care of yourself. Thank you.